Good morning, good afternoon, and good evening to all those present. My name is Ankit Malhotra, and I am a student of law at the OP Jindal Global University, and I am also the president of the student-led initiative called Jindal Society of International Law. I am grateful to the organizers of this conference for inviting me to speak at this event. I thank most especially Mr. Suren for extending the invitation for the conference entitled White Trans-Caucasia and for allowing me to present my thoughts on a paper which I had written recently. The paper which I have written talks about immunity of heads of state and the case of al-Bashir. Without wasting any further time, I would now like to discuss the case and also what the paper talks about. But before we do so, let us understand who Mr. al-Bashir is. He was the Field Marshal of the Sudanese military forces and politician and a war criminal who served as the seventh lead head of state of Sudan under various titles from 1989 to 2019 when he was deposed in a coup d'etat. He has been held guilty of all sorts of war crimes and crimes against humanity under the Rome Statute of the International Criminal Court. I list the details of the charges against him for perusal and reference. The factual matrix and the questions of immunity in the ICC remain the integral part of this discussion. The article also sheds light on the issues of immunity of heads of state and the arguments of indictment of Bashir. I also discuss the involvement of the United Nations Security Council as a relevant party to the dispute and being the modus operandi of acceleration in this setting and its tete-a-tete with the ICC and its jurisdiction. In addition, I also highlight the discourse around the head of state of immunity and the need to determine ICC's role on state immunity when it conflicts with public international law. As a response to this, the article will highlight the work of the International Law Commission around the discourse of immunity as a solution to the contemporary challenges on jurisprudence of international criminal law. Let us remember that international criminal law is not immune from the challenges that its judiciary, which albeit holds noble intentions, will divert from the rule of law. Let me now pass on to the finer details of the case and the charges pressed against Omar al-Bashir. I list out the details and I also highlight the important points of reference which I have plagiarized from the article itself and pasted over here. I also cite the authors which have supported me in this endeavor through their writings and also through informal discussions. The central point of discussion in Bashir's case revolves around immunity as a head of state. The ICC contends that Bashir is not entitled to immunity as he is prevented from enjoying it due to his actions and subsequent resolutions passed under the Chapter 7 of the Security Council. I'll list the details of the case and along with its citations for those who bear interest. Let me also share that the case of Bashir is a diversion from similar precedents where similar immunity was waived. The difference between the precedents and the case of Bashir is that in earlier cases, the immunity was invoked for a former head of state while Bashir was an incumbent. As such, analyzing the observations made by the ICC in the previous precedents would not serve as much of importance. As per the principles of international law, incumbent heads of state enjoy personal immunity from criminal jurisdictions, foreign or domestic. This personal immunity is also relevant in the context of their travels on and for personal affairs. Concepts of these and also of other aspects of immunity are enshrined in the Vienna Convention on Diplomatic Relations and also customary principles of international law. The immunity is also applicable when the heads of state is traveling, as I had suggested earlier, and remains wider than in comparison to the diplomats and the ilk. However, it must be noted that immunity enjoyed by the heads of state is also not permanent. For example, under the Rome Statute, a person's personal or official immunity does not negate the application of the ICC jurisdiction for crimes committed by him. I suggest and share sources over here which press upon the point as well. An important point for criterion which we'll talk about in later detail is also the case where the ICJ describes the scope of immunity as follows. A head of state enjoys in particular full immunity from criminal jurisdiction and inviolability which protects him or her against any act of authority of another state which would hinder him or her in performance of his or her duties. This was laid down in the Certain Questions of Mutual Assistance in Criminal Matters, the case against Djibouti and France in 2008. I have also listed over here other sources which might be relevant for your personal research. Let me also share that, however, it must be noted that the immunity is not permanent, as I suggested in my previous slide, and there remains a gap in how immunity is understood in terms of its practice and also how it is adjudicated upon in domestic courts. Let me now further proceed to understanding the immunity from a deeper perspective. As such, there exists a strong reason why customary international law places this distinction between the heads of state immunity and diplomatic immunity when the former is charged with committing serious international crimes. This is, of course, in specific reference to the case at hand. Furthermore, as I had suggested earlier, the immunity is not negated by the Rome Statute. I list the important article in reference to this as well in this slide, which is Article 27.2, which suggests that immunities are special procedural rules which may attach jurisdiction for crimes committed in the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. The Convention on Prevention and Punishment of Crimes of Genocide, as well as the Convention on Vienna and Diplomatic Relationships, bears reference over here. The rules regarding the immunity of heads of states can thus be summarized by the following points. Immunity enjoyed by the heads of state is a rule under customary international law. Although it bears resemblance, it is nonetheless different in comparison to the diplomatic immunity. Immunity is enjoyed by the heads of state by the heads of government of state. I again share relevant references in this regard in the notes section for further reading. Let us now swiftly proceed towards understanding the relationship between the International Criminal Court and the United Nations Security Council. To understand the overriding effects of the Security Council in this case, this paper, as I had suggested earlier as well, discusses the relationship between these two bodies. Arguments raised by the ICC highlighted the resolutions passed under Chapter 7 of the United Nations Security Council suggest that Bashir did not hold immunity for crimes committed under the Rome Statute when he was investigated in Darfur. Thus, these crimes were referred to the ICC under Resolution 1593, which was passed under Chapter 7 of the Security Council. It is not clear how the resolution binds the Rome Statute to render his immunity ineffective. That is because the ICC cannot exercise any powers under Chapter 7 of the Security Council. That remains the case because the ICC is not a part of the United Nations Charter. The Security Council is not, however, not empowered to delegate its powers to the ICC. According to the UN Charter, competent organizations for this purposes are the UN member states and regional organizations and the United Nations organs, and those like the ICJ fall within this broad umbrella. However, the ICC is not a part of this umbrella. If there is a possibility that the ICC may be involved to use these powers, then it has to be recognized as a part of being a part of the United Nations system. According to the Rome Statute, since it was signed and came into effect outside the UN system, there is no scope for that recognition. Articles 1 and 4 of the statute make the ICC a permanent organ that does not function at the behest of the United Nations. Even the UN and ICC agreement acknowledges the independence of the ICC. For reference, let me suggest that it is different from the other criminal tribunals, like the permanent organ that does not function at the behest of the United Nations, such as those of the International Criminal Tribunal of former Yugoslavia or Rwanda, or the Special Court at Sierra Leone, as its governance is done by the state parties. Thus, the far-reaching independent status of the ICC highlights that there is no means under the powers of Chapter 7 of the Security Council so that the responsibility can be delegated to the ICC, or it can bind non-parties of the Rome Statute to its powers. I highlight these very points and the relevant citations for those who bear further interest and reading in the case. Now let us look at the exceptions to immunity and specific references to the case at hand. The exceptions to state immunity, as is listed on the slide as well, does not protect against international crimes when charged by international criminal tribunals. If the court uses this ground to confer immunity, they need not rely on resolutions under the Chapter 7 of the Security Council, thus making them to some extent superfluous. As exceptions can also be said to exist in customary international law if there exists evidence of previous state practice and a corresponding belief in the legal validity. This, in other words, is also known as opinio juris. Any action of the Security Council which is violative of sovereignty, states are not obliged to follow. This can only be allowed when there is another exception in the customary international law orbit to the rule of immunity of heads of state. The exception is that the state of head immunity does not protect against international criminal charges, or albeit under the Chapter 7 resolutions of the Security Council. The rationale behind this is that the exception is that the international courts are free from bias of domestic courts and international organizations. That is, at least in the regards of the International Criminal Court. The effect of this understanding is that ad hoc tribunals are considered competent enough to study and persecute those who violate the immunities enjoyed by the heads of state and hence binding them as ultra vires. Let us now look at further cases to understand the situation better. The exceptions to the cases of immunities. In previous cases, such as those of Gaddafi, Charles Taylor, and Slobodan Milosevic, were of the former heads of state were charged by the ICC as former heads of state who do not have personal immunity, thus the charges were held valid. In other cases such as Laurent Gbagbo, the state itself brought the case to the ICC, thereby waiving immunity. I also list other relevant cases in this regard. But let me also add to that an exception can be made to the existence of a customary rule if there exists evidence of previous state practice and a corresponding belief in the legal validity of its practice. Due to a lack of precedent in this aspect, the immunity of an incumbent head of state for being charged for international crimes, the precedent that the ICC followed suffers from two flaws which are listed in the bullet points in the upcoming slides. The last argument that might hold for the ICC's decision is the arguments of neutrality before international courts, which can allow for a waiver of immunity. Excuse me. However, this understanding is also flawed. That is because customary international law is not dependent upon a good rationale. An examination of practice, especially of a more recent practice, demonstrates that there is no form of customary international law which grants functional immunity from criminal jurisdictions to foreign officials other than those in the four categories mentioned above. Those being diplomatic agents, heads of state and government, and ministers of foreign affairs, consular agents, and members of a special mission. Let us now look at immunity from a practical perspective and what have been the underlying discussions of this. As listed on the slide, historical practices show that domestic courts have denied functional immunity to foreign officials when they are accused of serious breaches of laws of war, aerial intrusions, or unlawful trespassing of foreign territories or maritime spaces. An interesting point of discussion in this aspect is the case of Abu Omar, who was one of the accused and claimed that the CIA agents prosecuted for the covert abductions of the Egyptian citizen Abu Omar in Milan should enjoy functional immunity from criminal charges in the Italian courts as being a foreign state official. Further in this aspect, the case also goes on to discuss in the Italian Court of Cassation in its judgment of 2012 that such a customary rule does not exist. That is, that it clearly rejected this claim, affirming the non-existence in international law of a customary norm regarding functional immunity of all foreign officials. According to the court, such a customary rule does not exist. This is confirmed by the absence of a uniform and consolidated case law jurisprudence of continuous and coordinated officials' declarations of state and an unambiguous doctrinal interpretation, says the court. It further adds that, to the contrary, the court espoused the theory according to which functional immunity is recognized by specific international norms only in favor of certain categories of state agents in the exercise of typical duties of their office. This position was confirmed in 2013 by the Court of Appeals of Milan and in 2014 in another judgment in the Italian Courts of Cassation. Moving forward, let us closely analyze the international jurisprudence on this aspect. The Vlasic case being a central point of focus, the Djibouti versus France case being another one, and let us now closely examine these cases. In this decision, the court denied the possibility of issuing an injunction against foreign officials, maintaining that they enjoyed functional immunity based on customary international law. However, this decision is open to criticism, not at least because the appeals chamber cited 4 cases in support of its view that is neither pertinent or tends to deny rather substantive values of the law. Some scholars mention the 2008 judgment of the ICJ in the case concerning certain questions of mutual assistance in criminal matters, in which France and Djibouti maintained opposing views in respect of the existence of customary norms of international functional immunity laws of its foreign officials. However, the court avoided making a pronouncement on that matter. In conclusion, international practice testifies, in a rather consistent and uniform way, to the non-existence of a customary norm regarding the functional immunity of all states from foreign criminal jurisdictions. The few judgments in favor of the existence of such a norm are based on erroneous or unconvincing grounds. Let us proceed further to understand the other cases on this aspect which highlight the underlying aspects of this discussion. Let me point towards the points shared in the slide and also the reference which I made to the arrest warrants case and ad hoc judge van der Wienaert, who stressed in the case of France versus Djibouti versus France. But before I do so, let's just have a quick glance to what the slides suggest. As held in the Eichmann trials in Israel and in the Blasich cases, functional immunity is a mechanism for diverting the responsibility of state officials to the state. Yet, the very purpose of international criminal justice is to attribute responsibility to individuals and to defeat the defense of official capacity as a state act. As late Antonio Casio observed, it is questionable to resort to the distinction between private acts and official acts for immunity from international crimes. If a foreign minister can be prosecuted for murder of his foreign servant in a fit of rage, it is a private act before a foreign court. Then it would be preposterous to assert the opposite, and he murdered numerous foreign civilians during his office term as an official act, which is condemned as a war crime, genocide, or a crime against humanity. Nonetheless, where the conduct is so far removed from the scope of official acts and functions that it should be assimilated to that of private individuals, not attributable to the state. Let me now offer what ad hoc judge suggested in the arrest warrants case. He suggested, and I quote, some international crimes can, for practical purposes, only be committed with the means and mechanisms of a state and as a state policy, and they cannot be anything other than official acts. Accordingly, if functional immunity were not to be lifted, prosecution for some international crimes might never, or in any event, rarely be instituted. There remains a technical challenge posed by the ICJ and some scholars. This being, individual responsibility and immunity are separate concepts embedded in substantive and procedural law respectively. So how come the principle of irrelevance of official capacity could affect procedural law? Immunity indeed lies in procedural law. However, for substantive law to be effective, there has to be procedural law. If the official capacity could bar criminal proceedings in the first place, then the aforesaid principle, which denies official capacity as a substantive defense, would hardly make any practical sense, says ad hoc Judge Wienaert. With those words, now let us proceed to the latter half of the presentation and paper. This is divided in two senses. I have listed the most recent work of the International Law Commission, whose job is the promotion and progressive development of international law and its codification. These slides share the most recent work done by the Commission, and what I shall share in my speech will be the work done over the past years. The ILC's first special rapporteur on the immunity of state officials from jurisdiction expressly concluded that state immunity from jurisdiction of consular officers, former diplomatic agents, and the ilk remains immune, thereby reinforcing the doctrine of absolute immunity. Adopted and undisputed by states, the ILC's rapporteur, it is understood that state immunity from the jurisdiction of the receiving state benefits is not restricted by reference to the distinction between acta jure imperi, acta jure gestoris. In short, as argued by the Special Rapporteur, state officials serving in former are entitled, under customary international law, to immunity from jurisdiction in respect of acts performed in their official capacity. This is further supported in the certain questions of mutual assistance case of Djibouti and France, which we discussed earlier as well. The rapporteur, to buttress further, suggests that the attribution of conduct using the law of state responsibility as an individual occupying the position of an organ of the state within the meaning of Article 4.1 of the Articles on Responsibility of State for Internationally Wrongful Acts can be said to have acted in his or her official capacity as an organ of the state. Let us move further, and as I suggested in the previous slide, the PowerPoint presentation which you'll see on your screen shares the most recent development, and I share what the background is. So let me start by sharing that nonetheless, while the conduct is removed from the scope of their official functions, it should be assimilated that of being a private individual's act, not attributable to the state. The ultra vires act of the official will be understood as those performed in a private capacity. However, one must not paraphrase expressions such as within the scope of the official's duties as state organs, in the discharge of their mandate, and even official acts. After all, they are not intended to connote a meaning different from in an official capacity. Nonetheless, they are prone to be misled. All things considered, one cannot rule out the flagrant abuse of immunity which was born out of the necessity and nurtured with reciprocity in a period of détente. The work of the ILC aims to highlight and underscore the efforts to prevent abuse of immunity. However, any given situation can only be analyzed on a case-to-case basis. The ILC special rapporteurs have dogmatically accepted, without any form of critical review, the old Kelsenian theory, according to which state officials have the right, in principle, to functional immunity from jurisdiction regarding their official acts, i.e., acts when acting in their official capacity and on state functions. The basic theory, which will have a strong impact on the future work of the ILC, is unfortunately not convincing. Thus, the issue is worth re-examining, especially in light of the most recent developments in practice and literature of the subject. To conclude, I offer three valuable insights and possible roadmaps towards more concrete steps and discussions on this issue. The first of those being the ICC Appeals Chamber. The hope in this aspect was that South Africa would appeal the Chamber's ruling, but the government of Jacob Zuma decided not to do so. Other state parties that have hosted al-Bashir, such as Jordan, who would not have been subject to the non-cooperation proceedings, ought to have considered requesting the appeals chamber to settle the matter of al-Bashir's immunity more conclusively. The second option seems rather more realistic in the sense that the ICJ's advisory opinion might clear the ground and provide some sort of clarity. While a proposal for a request from the UN General Assembly to the ICJ previously failed to gain momentum, there is no doubt that the court could help clarify the rules on state and diplomatic immunity under customary international law. Finally, the last option for the court's state parties is to specify the rules for which implementation of Articles 97 and 98 must be discussed. Amending these provisions may be not as realistic as it would have been at a later stage, but as the recent discussions in the ASP have shown a willingness of states and its parties to specify the rules on consultation procedures of Article 97. Discussions on this matter could form the first step in a longer political dialogue on the ICC's immunity regime as a whole. Just as an afterthought, I leave you with this slide, which also formulates the crux of the argument which I was suggesting in the third point. With those words, I would like to end my presentation, and I would like to thank the organizers for asking me to present my paper at this discussion. Thank you very much, and I hope you have an excellent conference ahead of yourselves. Thank you.